Good afternoon, everybody. Welcome to our Grandparenting Time webinar. Today, I'm so excited to have these two very wonderful people with me. We have the Honorable Shannon Schlegel from the Clinton County Circuit Court, and we also have Blair Johnson from St. Joseph County. So really, we have two people from St. John's and St. Joseph. Here we are. We are going to be talking about a lot of issues with grandparenting time today. Reminder that you can put your questions or comments in the chat. There's also a Q&A function that you can use, and I will be monitoring. I'll do my best to monitor both. We have had prior webinars where it got a little insane, and I apologize for that. But I think we have a more regular group of attorneys today, not individuals who have attended other webinars. So today should just be attorneys. Anyway, we're talking about grandparenting time, and you know, there's so many issues to talk about, but I wanted to share that Judge Schlegel and I, back when she was in private practice, we actually worked on a grandparenting time case together, and had I think a very good experience. And so she's going to hopefully share some insights that she learned from that case when she did it way back when. And then also maybe some insights that she has from the bench now that she's been sitting on the bench for a few years, like what would she like to see? Blair Johnson has also worked on grandparenting time cases, and so we're going to have some different perspectives here, and I'm looking forward to the conversation. All right, so this is how we're going to start. I'm kind of going to go through the statute in the order that the statute's presented. So first of all, everybody knows that the grandparenting time statute is part of the Child Custody Act. It's under MCL 722.27B. So that's just to get us kicked off. The first thing we're going to talk about is standing. And as a lot of you already know, not any grandparent can come in and ask for grandparenting time. So I just wanted to give both Judge Schlegel and Blair a chance to talk if they wanted to share some thoughts about standing issues, and I have some other comments I wanted to make sure we highlighted today. Blair, do you want to start off?
Sure, happy to, and thanks for asking me to come, and it's really a pleasure to be here with you. I've always been a watcher, and now I'm a
participator.
In the hot seat. That's right.
Hot seater.
That's right. Yeah, so I love you know, and in all full disclosure, I've done about a half dozen of these grandparenting time cases in my practice, 10 years of practice or so. But as you pointed out, Lisa, you know, the statute is really so well put together, and you know, given that it essentially had to be rewritten after Troxel in 2000 and 2004, we have this, you know, total rewrite. So it's a very logical progression through the statute. So you know, sub 1 of the statute gives five grounds, and a petitioning grandparent only needs to satisfy one of those. So the parents were divorced or never married, a parent dies, and then there's also, you know, the reference later on to the definitions in 722 about what a parent is, and there's a case law that says that it's a natural parent. So you know, legal does not necessarily limit you to that. So a natural parent.
So with that, one of the things I know you and I talked privately about it. One of the factors you haven't mentioned yet for standing, I think, is a very common situation that you see is when the grandparent has an established custodial environment with the child. Do you want to talk about that for a minute?
Absolutely. So you know, when I've done my initial consultation with grandparents who've come to me, my first inquiry is, you know, did the child live with you for any extended length of time in such a way that you served as essentially a surrogate? I think the most common situation that I have found has either been that, you know, one of the parents you know, maybe very young or has, you know, some mental health issues, and if the other parent is not engaged, they end up living with his or her parents, you know, for an extended period of time. And so those grandparents in that situation tend to be that second parent. They're doing all of those things to assist the legal parent in that function. The other situation is where one of the parents is deceased, and that surviving parent, you know, maintains a relationship with, you know, whether intentionally or just by circumstance, with the deceased parents, those grandparents. And again, they end up serving in that sort of surrogate role as parents. If folks come to me and they're more, you know, visiting folks, and they might know their grandchild very well, they might go to, you know, birthday parties and events and provide gifts, but if they haven't provided that level of support that is akin to a parent, then and that gets sort of later on into the different part of the statute, but that you know, when I talk with somebody, that's the first inquiry I make is, you know, give me all of the different ways that you have, you know, played a role in this child's
And I
life.
think we're going to talk a little bit more later about those grandparents who already have an established custodial environment, because I think that might change the analysis down the road. But I wanted to point out that when Judge Schlegel and I were working on a case together, it was kind of a similar wrinkle to what you're talking about, Blair, because we had the parent who later died was living in the home with her parents, and they were raising the child all together. So even though the grandparents weren't solely responsible, right, there was like this daily participation. Judge Schlegel, did you want to add anything about that aspect?
No, just that I agree with you. I mean, that was the situation in our case. Mom and child were living with her parents because, and the parents had never been married. Dad was in the military, and then mom subsequently died. And so initially, before I got involved, the case was filed as a guardianship, and some different things happened, but eventually everything got on the right track and it became a case regarding grandparenting time, and whether or not the denial of that grandparenting time was a substantial risk of harm to the child, which ultimately the court did find that it was, and Lisa can talk more about that.
We have a question, and I'm sorry, I think it's Philip, and I think I know which one it is, but it's not letting me see the last name. Oh yeah, it is who I thought it was, but let me just move my cursor over. Philip Schlegel, I think he's over in Lenawee County. His question was, how important is the distinction between natural and legal parent? I think I know the answer, but before I spout out what I think, I'd welcome either one of you to, if you feel like you have a comment about that.
Go ahead, Blair. Go ahead.
Well, I'll defer. Lisa, if you want to, I'm trying to load up the statute here on my computer and I can't seem to get it connected. I wanted to have that in front of me.
Yeah, so even though,
Go ahead.
like Blair mentioned later in the statute references a natural parent, but it also says that you have, like, if it's a father who hasn't established legalhood, like through an affidavit of parentage, he has to establish that first before the grandparent. So I think, I don't know why they use the term natural parent, because in the standing section, to me, it looked like you had to, if the child's parents have never been married, blah, 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 and paternity has been established by the completion of acknowledgement of parentage, or an order of filiation or some determination of the court. So I think it has to be, the parent has to be a legal parent in order for the grandparents to have standing, is how I read that. And Tracy Rink asked, this is a really interesting wrinkle that we didn't have when the statute was written, we weren't dealing with. Her question is about the reference to natural parents and same-sex couples who might both be legal parents, but only one has a biological connection. So I think the way I just answered that one question might answer her question. Any comments from Blair or Judge Schlegel?
I would agree with your analysis of that, Lisa.
I mean, I think, Tracy, as long as they've got to be legal parents. So in your hypothetical, they are legal parents. I wanted to point, before we get off standing, I wanted to point out two other things, because this came up years ago where the question was, you know, the parents' rights have been terminated. Can the grandparents still seek grandparenting time? And the Court of Appeals said in a published opinion, no, once the rights are terminated, that completely severs the rights of the grandparent. Well, that has been rolled back because the Michigan Supreme Court later issued an order where it said, as long as the child hasn't been adopted, right, that the grandparents still have standing to pursue grandparenting time. So if the child's on foster care or whatever, they can still pursue it. So I think it's a really important distinction to make, because the termination of parental rights does cut off a lot, but it doesn't cut off the rights of grandparents in some cases, I guess.
Yeah.
And one other thing, I guess, relevant to that, hiding under section 13 of the statute, and I don't know why it's not in the standing section, but when a child's been placed for adoption, not just adopted, but placed for adoption, then the grandparents can't pursue, or the trial court can't award grandparenting time. So basically, that whole placement for adoption is what cuts it off, not the termination of parental rights. Okay.
Well, that sub 13, does allow for it in the exception of grandparents of a deceased parent. Right. We kind of had that
for a step parent adoption.
For a
right?
step parent. Yeah.
Thank you. Thank you for, I'm glad you pointed that out. That's a very good point. Okay. So before we get to the next little section about what we're going to talk about, I think the takeaway that all of us agree on is that if you have a grandparenting time case, walk in your door, the very first thing you should do is pull out the statute and read the entire thing. It's not that long, right? I'm looking at, I printed it out years ago. It's 3 pages. You're going to want to write it out, read it, print it out, mark it up, because there's a lot of meat in these 3 pages. There's just so many details. And it's one of those things where, Blair, you said you've only done 6 grandparenting time cases, but honestly, I don't think there's not that many, right? Like most people don't have like a high volume of grandparenting time cases. So, if you're doing once a year or once every other year, you have a grandparenting time case, honestly, you should take out the statute every time you're working on one and just read it from cover to cover, all 3 pages, and then you'll kind of reframe yourself for whatever type of case you're working on.
Yeah, and I think even Judge Schlegel, you mentioned to us in our pre-brief before we started, and however long you've been sitting on the bench, you've yet to have one come in front of you.
Correct. I'm going into my 3rd year, and I've yet to have one. And I preside in 2 counties, Clinton and Gratiot. And I only had the one that I had
in private practice.
Right, with you, Liisa, where you took over on the appellate portion of it. It was a big one, but it was the only one that I had. And I feel like that's how they are. I feel like when you do have one, it will be significant because there's just so far a few that I think really meet this threshold of the statute.
And we're going to get to that in a second. I have another question from the audience, and this one's anonymous, but it's asking whether extended family can petition for time. And the answer is no. I don't know that there's any authority for anybody other than a grandparent. It has to be a grandparent. It can't be an aunt, an uncle, or brother or sister, or anything like that.
Yeah, the history on this was in just getting ready for this. It was really fascinating. The Troxel v. Granville is the case that went to the Supreme Court that was out of Washington State, and in Washington State, their statute was very broad. It said anybody could petition for visitation. It wasn't just limited to grandparents. And the court said that, no to that because of the constitutional right to raise your children. And then, interestingly enough, it was DeRose in 2003. And in reading DeRose, it's really an interesting opinion because that court had to interpret which was a plurality decision written by Judge O'Connor in Troxel with 2 concurrences from Judge Thomas and Judge Souter, I believe. So understanding the rationale to then apply to Michigan's grandparenting time only statute was quite the exercise, which I thought was really fascinating.
I think it's really interesting, and I'm glad you brought up Troxel because it's really important for grandparenting time cases, but it's really interesting to remember. I mean, we cite Troxel all the time in all kinds of custody and parental rights cases. It's like the case that we cite from the United States Supreme Court, but it's actually arose out of a grandparenting time context. I just think it's really fascinating. So one of the things about the grandparenting time statute is that it's all about a fit parent's decision, which leads me to the next topic I want to talk about. What does it mean for a parent to be fit? And I wanted to point out in the statute, it talks about how 2 fit parents can come together and deny grandparenting time. So even though the grandparent has standing under one of the topics that Blair was covering earlier, if those 2 parents come together, they can do an affidavit and say, we're going to deny grandparenting time. And that's, in my mind, that's the end of it. So I did have a counter example from case law where something different happened, and I'm going to talk about that. But I wanted to see if you folks had anything to say about the affidavit or 2 fit parents coming together to deny grandparenting time.
Yeah, go ahead, Judge. No, it's okay. Go ahead.
I was just going to say, the presumption is that the parents are fit. And so, unless maybe, I think when we were discussing prior to meeting today, the examples that we came up with where perhaps a judge would find that a parent was not fit would be if there was an abuse and neglect case that was opened or something to that effect. But otherwise, parents, and even if the parent, we were trying to come up with different examples where if parents are divorced, parents could be divorced, they're still fit parents, and they may sign an affidavit that says, we don't want grandparent A to have any contact with our child, and the law supports that.
Yeah.
So you would have to show that a parent is not fit.
So I do have a story to tell about that, but I want to make sure Blair doesn't have something he wants to say.
No, the presumption, I think, absolutely.
Yeah.
Is
so,
right.
And I agree, there is a presumption in this. I don't know if it's explicitly in the statute, but there's a fitness presumption period when you have parents. And I think a CPS case is a really good example of when you might be able to question that, especially if there's been an adjudication. There'd have to be an adjudication at least, right? I had a case, and it turned out to be a published case, Gearing versus King, where the two divorced parents could not get along and agree on anything, but they eventually came together and agreed to deny grandparenting time. And the judge ended up holding a 4-day trial on whether they were fit parents, and ultimately decided that they were not fit and awarded grandparenting time. So the whole issue, there was a couple issues on appeal. I challenged the ability of the trial court to put the parents through that fitness trial, because in my view, like without having any CPS adjudication or anything like that, why are we making them go through a 4-day trial to prove that they're fit so that they have the authority to deny grandparenting time, even though they signed this affidavit? The Court of Appeals did not rule on that aspect of the case. So that's kind of like an unresolved issue. The Court of Appeals reversed because the facts were against the great weight of the evidence that the parents were unfit. And the court in Gearing said it defined fitness for purposes of grandparenting statute. A fit parent is one who adequately cares for his children, citing Troxel. So again, I don't know that you need to have a 4-day trial to determine whether a parent, I don't know how, I just, sometimes these trials that go on so long, I can't get my head around, how did that happen? How do you have a 4-day trial on this one little aspect of the case about fitness? So I think the idea is that, fit parents get to make decisions, and that's kind of where we're going to the next part of this analysis. Now we're getting some questions. So before I jump to substantial risk of harm, I want to make sure we're covering questions. Okay, so Donna Medina asked about a situation where her client died, the father died before he could become a legal parent. He was a putative father, right? I don't know. I mean, can you do an affidavit? We can't do an affidavit of parentage if he's died, right? Could you get an order of affiliation? Do you think a judge would entertain an order of affiliation? There might be other reasons to have that legal parenthood. They might be able to benefit. Mother applied for Social Security dependency benefits. I'm thinking, Donna, what you mean is that on the basis of the father, right? The deceased father. So if you're able, there's a lot of rights that go along with being a legal parent and for the children of the legal parents. So that I'm thinking there's a way to make you a legal parent even if you passed. Have you seen something like that, Judge Schlegel?
No, that's very interesting though.
But Donna experienced it, and she said the judge did. I don't know if the judge did an order of affiliation, but the judge did grant some grandparenting time. I'm waiting to see if she pipes up and says anything else. Okay, another question.
Well, the interesting thing about that is then there's no relationship between the grandparents and the child. Well, I guess there would be if the child was born. There's the biological connection with the father.
Mm-hmm.
The father was never around when the child was there. So I guess I may be mistaken.
So, oh, good. I'm skipping around a little bit. So if you've asked a question, I haven't got to it. I'm keeping it in mind. I'm just kind of doing things in the order. Lisa Schmidt, thank you. There is a route to establishing paternity in probate court under EPIC. We don't know the section offhand, but thank you. There is some sort of mechanism to do it. Lisa, if you find that, you could post that, please.
And Beth McCree also mentioned that order affiliation with a grandparent's DNA. And she had that in the case.
Okay, good. So now we have 2 attorneys who have been able to get something done after the death of the parent. Excellent. Randy Velzen asked a really good question about whether an incarcerated parent is a fit parent. I have my thoughts, but before I speak, I want to hear what Judge Schlegel and Blair might have to say.
I've never, so I had a grandparenting case where the grandparents, the father was in prison. He wanted his mother to have parenting time, so he was in favor of it, right? So there was no joining a meeting of the minds around fitness. But I think it comes back to your example, Lisa, that and as Judge said, there's a presumption of fitness,
Right.
and I guess you could litigate on that. I don't know the avenue that you'd have to plead specifically to get there, but if he still has some, legal custody and parenting, time, even if it's reserved, there's a presumption.
Anything to add, Judge Schlegel?
I would even wonder, even if he didn't have legal custody, I mean, if his parental rights haven't been terminated, incarceration, it's been a long time since I've done that type of work. Last I knew, incarceration was not a reason stand alone for termination of parental rights. So I don't see how that alone would make a parent unfit.
That is exactly right. I was going to add, I mean, the Michigan Supreme Court in the Sanders case talked about how just because you're incarcerated doesn't mean you don't have the right to make decisions about the care, custody, and control of your child. I think that all ties in with the fitness concept. So if you're incarcerated for abusing your child, well, that may be a different story. But I think it might depend on why you're incarcerated, and just the pure fact that you're incarcerated does not remove the presumption that you are a fit parent, is what I think I would say. Lisa Schmidt did post that section, the EPIC section, in the chat. I'm going to actually write it down because I want to take a look at that later. Thank you very much, Lisa. Okay, so moving to the next topic, which is really kind of the heart of grandparenting time cases, is proving the substantial risk of harm that denying grandparenting time will cause. And that the statute actually says, let me just pull it out so I can use the right phraseology. Grandparenting time, blah, blah, blah. Where'd it go? Well, it's something about the emotional, psychological, physical well-being of the child. That was the kind of the phrase. I was trying to say it exactly like the statute said it.
It's under sub 4, that
I was
presumption
looking,
that a
that's why I'm on the wrong page.
fit parent's decision to denying grandparenting does not create a substantial risk of harm.
Mental, physical, or emotional health. Mental, that was what I was looking for, mental, physical, or emotional health. So let's talk about rebutting that presumption. So first of all, there's a parent presumption, and then there's a presumption that the parent's decision, is correct, right? That there's not going to be a substantial risk of harm to the mental, physical, and emotional well-being of the child. So the grandparent really has an uphill battle, right? But it's only by preponderance of the evidence standard. So I guess that makes it a little bit easier, but let's talk about rebutting the presumption. We have lots of cases that talk about it, go different ways, but if you have any, thoughts you want to share from your own cases or life experiences.
Sure. So, getting past, getting past the, I think, fairly rare meeting of the minds of two fit parents denying grandparenting time. Now we're into what I consider to be the two-step analysis. So the first step is, the grandparent, that there's a presumption that the denial by that parent is reasonable, and that it doesn't create a substantial risk of harm, and a preponderance of the evidence that the grandparent must show to overcome it. That by not allowing me as a grandparent to have time with the grandchild, there is, in fact, a substantial risk of harm. And as we were discussing before, I've not ever had to rely on experts in the cases I've had in probably two different counties, two of the three counties that I've practiced in over here, where I brought these. The court has inferred a risk of harm where that grandparent is serving in that surrogate parent capacity. As we talked about it, and one of the issues is, getting to this level of harm requires a grandparent to have access in a lot of cases. And if they're being denied access to the child, how are you going to get that expert opinion? You know, and I know you've got some stories around that, but from my personal experience, I've been successful with the grandparent, you know, providing an affidavit and testimony and support based on all of those parenting type roles that they have fulfilled over an extended period of time. Usually it's at least 1 year or longer.
So I definitely want to talk more about expert witnesses because there's a lot of cases on that topic, but I think the example you're providing is really a really key opportunity for a grandparent to, when there's an established custodial environment with the child, to prove that there is a risk of harm without necessarily having to have an expert. So if you're the grandparent representing the grandparent and you've been denied access to the grandchild, I mean, what kind of evidence would you put on, or what kind of evidence would you like to see in a case about that established custodial environment when you don't have access to the child for purposes of making your case?
Yeah, I'm just trying to think.
I mean, I'm thinking like, would you maybe get teachers that know, like maybe you saw teachers at school or people from church.
Certainly.
Judge Schlegel,
Yeah.
I feel like I think you had a bunch of witnesses, if I'm remembering correctly. It's been a really long time. But people that were involved with the family and knew the grandparents' interactions and relationship with the child. That seems to ring a bell for me. What do you remember?
I do remember this case because it was very, it became very personal for me for a lot of reasons. This case was a little different in that by the time it got to me, a significant amount of time had gone by where the child didn't see the grandparents. She was a young child. She had been living there. Mom passed away unexpectedly. Dad was in the military. Dad came back. He was out of state. He came back, picked the child up to take her to lunch, and then they never came back. So a significant amount of time went by. I don't exactly remember how much, but that was not favorable to our case. I could talk about what things were like while she was living there, how much an integral part of her life the grandparents were. But I had to look at, I did get an expert witness because I came from a perspective, first of all, there was a cultural component to my case. My family is Latin American. And so extended family was a very important factor in my fact pattern. I brought an expert witness on who never saw the child. We were not allowed access to the child. We were explicitly told no. But I brought that expert anyways to talk about grief because you had a child who just lost her mom, and then 3 days later, she's taken away from her grandparents and extended family that she'd been living with for
like 4 years. Right.
Yeah. So the angle that I took it from was from that perspective, and then taking into consideration the witnesses that I had that testified what life was like while she was living with grandma and grandpa. And so that was the angle that I took. These cases are very fact specific. And so my opinion now, sitting where I'm sitting now, I'm really glad that I brought that expert witness. I wasn't sure how that would be taken because she'd never met the child. But at this point, every little fact that I had, every little thing that I could do, I felt like just really bolstered the case for this little girl. And that's really our perspective when we were coming from, was this child, and how could this not have been a risk of harm for her to be taken away?
I think it's really important, and this could apply to other people's cases as well. The expert witness about emotional psychological development of a child of her age. I think she was 6 at the time, in kindergarten. What would a child who is 6 who has just lost the parent who they're living with like? And then what would it be like? What would it mean to that child when the rest of the family disappears? And the expert witness testified quite eloquently that it would be for that for a 6-year-old child, and it might be different if it's a 10-year-old, but for a 6-year-old child, it would be like as if her whole family had died, that she won't understand, well, I know my mom died and now my rest of my family's gone. They must have died too. And I mean, it was kind of like, it was very heartbreaking to read that transcript. But Judge Schlegel, you did win that case, and which was upheld on appeal, because I do think the expert witness was a huge help. And not that you need it in every case, but, and Blair has some great examples of this as well, that you don't need it. But I wanted to point out that in the Varan versus Grandman case, which was a published case from 2015, the grandparents in that case did have an expert, and then the expert was qualified, and then the judge decided that the expert's testimony was not reliable, and then basically unqualified the expert. So the parent, I think, ultimately won in that case on appeal against the grandparents. But it kind of highlighted for me that you have to make sure your experts, no matter whether they meet the child or not, they have to satisfy Daubert, right? That they have to have the right kind of experience and training and qualifications and everything that you would do for a Daubert hearing. Did you have to have a Daubert hearing, or it was more like a voir dire?
No, I didn't, but my expert, I don't know if you remember who it was or not.
Lisa, I do remember.
Okay, okay.
I don't forget. I mean, like cases like that, you just never forget. And yeah. I didn't live it like you did. I just lived the appeal, which is not anything close to what a trial attorney goes through, honestly. But I will never forget that case.
Yeah, I know. I just got chills. The expert is a well-known expert in our community and in the county in which I was practicing.
Well respected, yeah. Mm-hmm.
Well respected. And so I think that was helpful too. And I will say that in our case too, another factor that the expert witness touched on was that the child hadn't been living with dad. And dad is the one that came, picked her up, and then he took the child to his parents' house, and then he left again. And so, all of these different facts, I mean, these are very fact-specific cases, and all of these things were factors that the court took into consideration. And he actually, Judge Sauter, even though the standard is preponderance of the evidence, I'm so thankful that he actually found by clear and convincing evidence. And Lisa, you can talk about what the statute says about that. But that was extremely helpful by the time the case got to Lisa. They appealed the decision. The parent.
Yeah, I think it is a preponderance standard, but I think what happened was when the legislature did this complete redraft that Blair talked about after the DeRose decision, they did a complete redraft and they put in a little safety valve. So basically, if a court finds that this statute would be unconstitutional by using the preponderance standard, then use the clear and convincing standard. So it's kind of like, we don't want the whole statute to fall apart again like it did last time. So we're going to put this little safety valve in here. So to my knowledge, no court has, said that the preponderance standard is unconstitutional. But like in that case that Judge Schlegel and I worked on together, the judge just went ahead and used a clear and convincing standard just as a precautionary, and there was so much evidence. So,
well, the Varan case that you cited did,
mm-hmm.
they did rule that POE is sufficient enough.
Oh, thank you. Thank you, Blair. I hadn't reread it today. I appreciate you pointing that out. So unless the Supreme Court says otherwise, preponderance is it. Okay. Liisa Schmidt has a really good question. So I'm going to see if Blair and Judge Schlegel can answer, but if other people have comments in the chat for her as well, that'd be helpful. Has anyone had success filing a discovery motion to present the child for an expert evaluation per MCR 2.311? Lisa, you're making me pull up my court rules. Good thing they're handy. So that's just a standard civil rule. 2.311, motion for order compelling disclosure or discovery. Which sub rule is it, Lisa? I'm trying to see if I can quickly find it. Any comments? Any thoughts about that?
I've never had to use an expert. So.
The rule's actually a little bit longer than I thought, so I'm not going to go ahead and read it to all of you. Sorry about that. I'm going to jump to the next question. So Tracy Rank, was a referee for a really long time in Oakland County. And so she is now in private practice and does mediation. And she made a comment here in the chat about how she probably saw about a half dozen of these cases. So Tracy, I don't know if she was a referee for 20 years. I know it had to be more than 10 years, but a half dozen is not very many, right? Going back to the earlier comment, we had grandparents who had a close and loving relationship with the child or children as a grandparent, not a surrogate parent. But ultimately, court did grant monthly visits with the grandparents. None of the cases I had were appealed, as far as I know. They could be settled. Okay, 18 years. Thank you, Tracy.
Yeah, so I do want to walk back. I mean, I think the strongest cases, you know, that I've seen in my practice are those cases as a surrogate. But I think this also gets into, you know, what we'll talk about here shortly, with what is in the best interest, that the court's not bound to necessarily give a grandparent reasonable rights, which may feel like too high. That, you know, there's plenty of space in between, like Tracy said, that a bond and a relationship with a grandparent, you know, might equate to something that is a monthly visit. And certainly, you know, because of that space, I know that's why, I'm pretty sure that's why they had that provision, you know, built in to say, before we get into that second part of the analysis, we're going to send you to ADR, because
Right.
you might be able to find common ground.
I'm glad you brought up the reasonable rights, because I wanted to point out that there was a case from 2015, Falconer v. Stamps, which the issue was excessive grandparenting time. So the court in Falconer talked about how the statute says reasonable grandparenting time. What does that mean? And basically in Falconer, it says standard parenting time for what you'd give a non-custodial parent is not reasonable grandparenting time, right? That's reasonable parenting time for a non-custodial parent, which I think what they're referring to is alternating weekends with a midweek visit, right? So I had a case where I represented the foster mom, but the children had been placed to adopt with her by the time. And this was actually another published case, but I don't remember if this issue came up. It came up, but I think they resolved it on the fact that it had been placed for adoption. So the name of the case is In Re Keast from 2008. But the foster mom who had the children placed with her for adoption had a case against the grandparents, and the judge awarded the grandparents, basically the children were young, like 4 and 6 or 3 and 5, and the judge gave the grandparents every time the children would be in daycare, which is like every day, all day, 5 days a week, basically giving them the daycare time. And of course there was travel involved to get, like, there was a 45-minute distance between the two of them. At the end of the day, that didn't need to be addressed by the court, if I recall correctly, because the children had been placed for adoption. There wasn't any right to grandparenting time at all. But I've seen other cases where, you know, you can't just, well, I had another case where there was like every weekend, and you can't do that when it's interfering with the rights of the parents. Now, I know you're looking, Judge Schlegel, you're looking at me. I remember our clients got more grandparenting time, but it wasn't interfering with the father's rights because he wasn't around, and it would be totally different, I think, if he were in town. But I think they got every weekend, or there was something. Do you remember what the amount of grandparenting time was?
I don't remember, because I think they ended up working something out that was
Good.
different than what was originally ordered, but it was a significant amount of time.
Yeah. So Blair, you mentioned, or maybe it was Tracy mentioned, monthly grandparenting time. That is something less than, quote unquote, the reasonable rights every other weekend. So I think as a rule of thumb, you know, the judges, if they're going to be awarding more than like monthly grandparenting time, they need to really have a good reason why. And I think in the Benavides case that Judge Schlegel and I have been talking about, there was a reason to do it, but there's been a lot of other cases where the judge just, feels really bad for the grandparents and wants to give them a lot more time, but that's kind of infringing too much on the parents' rights to the care, custody, and control of their child. Okay, so it looks like I answered all the questions. Good. I did want to talk more about experts. We talked about the Dauber issue. There's just been a lot of cases where the grandparents win in the trial court, but then it's reversed on appeal. And the impression I've gotten is that the lack of an expert made a difference for the appellate courts. And I know the Keenan versus Dawson case was like one of the really big grandparenting time cases. I forget what year it's from, but it was over 10 years ago. And that was where the father was suspected of killing the mother. And the mother's parents wanted to have grandparenting time, and they had an expert witness about how the grandparents could help keep that relationship and memory alive, because the child would have a relationship with that side of the family. And if she was denied access to that side of the family, she wouldn't have any memory of her mother. So anyways, that was another one. The case ended up turning, I think, on the expert witness, and having an expert witness made a difference for the grandparents. Blair, do you have any other thoughts on expert witnesses?
I got none, because I've never used them. So, I mean, in all honesty, I think it really comes down to just that relationship that's there. If a child's in counseling and you have access to that counselor to be able to say, yeah, I mean, to tell the court, this is how this child talks about grandma and grandpa, and it's one of those things where and that's why I think we're hearing so many, things in the comments about settlement, because it's there's an acknowledgement, that a parent is a parent and a grandparent is a grandparent, even if the other parent is gone. And yet the dynamics there for a child are really delicate. And so I really, I guess for me personally, I really take a deep breath before thinking about having an expert probing this child for information. And it's there's a part of me that just my stomach turns.
Well, and here's an idea, and actually, Judge Schlegel, I think you're the one that gave it to me, so I can let you speak about it, but like, were you the one that mentioned about the other day when we spoke about if the child was in counseling and therapy already? Yeah, do you want to say anything about that?
Well, and I know often therapists, they don't want to testify, and I get that, but that might be a situation where it's helpful. If it's just the same with a custody dispute, if there's things that's going on with this child, since the removal of the grandparenting time, or since the installation of grandparenting time, or is the child having outbursts, bedwetting, I mean, just, different things that can happen. I think certainly in that case, that expert witness would be helpful. I knew that the other side was not going to provide access to the child. It was very hostile. It was a hostile situation all the way around. And so I knew that I was not going to have a situation where the expert was going to be able to sit down and do an assessment or evaluation of this child. I knew that. So I called the expert anyways. But if this is a situation where maybe some of these unusual facts are not part of the case, and it's just maybe a little bit more of a simple case, I could see that if you have other people that can testify as to what that relationship looked like, how was the child doing now. But one of the things that I have learned is that most cases are not that easy, and cases have a lot of different intricacies, and so I think from where I sit now, if in doubt, have an expert. Because I don't know. I mean, Liisa thinks I would have won without the expert. That wasn't a chance I was willing to take. Again,
I think it made the appeal better. It definitely made the appeal better. So I was very happy you had an expert. So now I have a question for you, Judge Schlegel. And it's relevant to grandparenting time cases, but also all the custody cases we see. So there's so many times we have, he said, she said, mom's version of the facts versus dad version of the facts. And in grandparenting time, it's going to be the grandparents testifying about how they feel, what they've seen, versus the parent who's still, alive. My feeling is that having those other witnesses, whether it's a therapist or somebody from church or somebody from school testifying about what the child is experiencing, like if the child seems distressed, or if even if they haven't observed the relationship, that it would be really helpful. I guess I'm concerned because you're not the first person to say, oh, this type of witness doesn't want to testify. A therapist is not going to come on if they know they're going to have to testify, right? as a jurist, how do you look? I mean, I would, are you looking for cases where they can bring in other types of third-party witnesses, not just, you know, the family members?
If it's helpful, you know, I mean, I go back to when I did a lot of the abuse and neglect work. And so teachers were very instrumental in testifying what is going on with this child in school. So absolutely. And I'm not saying that therapists don't come, but I know that they don't like to, you know, they don't like to be put on the stand. But and it's just one piece. You know, if I had a therapist that said, absolutely no grandparenting time, I need to know why. What are you seeing that's telling me that?
Yeah.
You know, not just because the therapist says that. I mean, there needs to be other things that I take into consideration. So to me, the more that there is, that's substantive, not just 15 people standing up and saying, yeah, grandma took child to get ice cream on a weekly basis. I need something a little bit more than that to get my teeth into. But I think it's helpful. I mean, and I think too, Liisa, because I had that perspective of wondering, oh no, you know, that feeling of victory was short-lived when they filed the claim for appeal, and I didn't know what was going to happen with that case.
So we've been talking about the substantial risk of harm and proving that and how hard it's to prove, but we also have to remember that after that burden, after that hurdle is passed, there's still best interest analysis, which leads me to the whole reasonable preference of the child. And I don't know that I can think of a case that I've worked on where the child was interviewed. Maybe I don't remember. Any experience with that in your cases?
I don't believe any of the children in the cases that I've had were interviewed in camera. Mm-hmm.
This court shall consider all of the following. So I feel like that means, just like under the rest of the Child Custody Act, the judge is going to have to go through each and every factor and make a finding, right?
Yes.
The child's reasonable preference, if the court considers a child to be sufficient age. There's some interesting factors that are different than other child custody factors, so it's like definitely something you want to take a look at. So Philip Shaler had a really interesting question. It's a little bit off tangent, sort of a little bit, but it's so interesting. I think we should bring it up before I get to my next topic. He's talking about a situation where the grandparent is serving as the guardian and then is denying the parent reasonable parenting time. And I feel like that issue just came up with pretty recently in one of my cases. So I would love to hear if you folks have anything to say about that. Like if there's, what are the parents' rights when the grandparents are in a guardianship role? It depends. Like if it's a limited guardianship, right, there might be a parenting time order. But if it's just a regular epic full guardianship, I'm not sure.
So these are the guardians denying parents.
Mm-hmm, mm-hmm.
Yeah, that's because I know that there's case law in the statute that talks about guardians are not afforded the same right as a fit parent.
Right.
To they don't have that protection that a fit parent does, but this is a guardian. Yeah.
I mean, I think a parent would just at that point just file a motion to get some parenting time, right? I don't know.
Yeah, I don't think it.
Judge Schlegel, you just cut off. I can't hear you.
Can you hear me?
Yeah, there you are. Okay.
Okay. I don't handle, this is not an area of the law that I handle, but I feel like when I was in private practice and I handled it, there would just be a motion modify the terms of the.
Thank you. Yeah, modify, because you can still have a guardian and the parent. Oh, here's Greg Crockett. Judge McGivney recently held a limited guardian grandmother should not allow parenting time. That's interesting, because a limited guardian, not limited guardianship under, because there's a limited guardianship where the parent has a parenting time plan, and if they don't follow it, then their rights can be terminated. So I think that he's referring to a different, I'm not sure if he's talking about the same thing. He said limited guardianship. That's interesting. I don't know. It seems like the whole reason that a parent agrees to a limited guardianship is they get more benefits from it, but it also poses some risk if they don't follow it. So I'm not sure what happened. I don't want to speak about anything in that case, but it seems like that gives me a little bit of pause to not know what actually happened. So there's a couple other things I wanted to get to today. We only have 9 minutes left, but I wanted to, I guess, point out, talk about the issue of interim orders. So a lot of times in custody cases, when two parents are against each other, there's an interim temporary order while we're waiting for the actual evidentiary hearing. I've also seen it in grandparenting time cases, and I basically threw a fit, and I will, if that happens to anybody, please call me, because I think that's a really important issue that needs to be like definitively resolved. Have either of you seen interim orders for grandparenting time before the evidentiary hearing? That's good. If anybody in the audience sees that, I think you can't award any grandparenting time, even a minute, until they've proven, right, the substantial risk of harm by denying grandparenting time. So I think it's completely inappropriate to do any kind of interim award. And I mean, there's a question of whether it should be appealed immediately or can, you know, whatever. There's all those questions, and maybe that's not feasible, but it's definitely something that maybe isn't even worth a motion for reconsideration, because I think that the statute doesn't support it. We have some more questions. Tracy Rank, is there any risk in a parent filing a motion against a grandparent who has possession of the child that they are conferring standing? Wait, let me read this again. Is there any risk in a parent filing the motion against a grandparent? Oh, I see. You're asking in response to Greg's question about the grandparent is the guardian. I don't think so, because a grandparent would already have standing by the fact that they have possession. Because by having possession, presumably there's a facts to establish the established custodial relationship, right? And that the child, because it's not just, let me just pull out this statute again. It says, in the year preceding the commencement of the grandparenting time action, the grandparent provided an established custodial environment, whether or not the grandparent has a custody under court order. So I don't think that would change anything. Okay, so there's a lot of really interesting provisions under the grandparenting time statute, starting with sub 7. After we get, you know, we've been talking about the heart of the statute and how to prove your case. There's some really interesting provisions, and actually I wanted to point out a couple of them here. And I actually have a question, maybe Tracy Rink will answer it for me. So one of the things under sub 7 is that once the presumption is rebutted, so you rebut substantial risk of harm, the court, rather than going through best interest, right, and making a decision, the court can refer it to friend of court for ADR. So I don't know if either one of you know, and if you don't, hopefully Tracy Rink or some others who have served as referees can help out. Who does that go to at the friend of the court? Is that going to like a conciliator? Is that going to a referee? Have you ever had, either one of you ever had that happen?
No.
And I'm hoping somebody pipes up, because I'm not sure, like, if there's a certain context or certain facts that need to be there before the judge would do that. May refer the complaint to ADR. That's it. It doesn't really give any guidance about when the court, I guess the court just doesn't feel like deciding it. Like,
well, and it also doesn't specify when the court's supposed to have a hearing.
Yeah.
If ADR is unsuccessful, just as the court
yeah,
will.
Yeah, good point. There's an interesting provision about how the grandparent can't file for grandparent time more than once every 2 years.
Mm-hmm.
So I think I've had a question come up before, like the grandparenting time motions filed on, you know, day 1. It's denied. There's an appeal. By the time the appeal's decided, 18 months have gone by. So do they just have to wait 6 more months to file a brand new motion for grandparenting time? I think probably, because it's probably going to run from the time of the original petition, right?
I mean, that's the allowance for good cause. The court could say, if you haven't seen the child during that entire period, I mean, the whole point is having that relationship, and if it's not there for 2 years, that might be an exception.
I have not litigated that good cause issue. The other thing I find really interesting, this sub 8 that talks about that 2-year period in good cause, it also has this sentence: upon motion of a person, the court may order reasonable attorney fees to the prevailing party. So does that, I don't know the answer to this, but does that just apply to that good, because it's under sub 8, does that only apply in the context of that second, grandparenting time motion, not to any grandparenting time case, right? I think it has to only apply
Seems
to
like
that.
it. Yeah, I think, yeah.
I take that it means with regards to this provision, because if you have someone who's excessively filing motions, maybe.
Yeah.
Yep.
Good point. Tracy Rink, thank you for providing an answer. In Oakland County, at least, and I know every county is different, the case may be referred to the family counselor or for a referee hearing, but it would typically be after the judge has determined that some yes, that because they have to rebut the presumption first.
Yep.
That means probably some grandparenting time is going to be awarded once we get through the best interest analysis. That's a good point. Okay, so a family counselor, is that like the social worker at the friend of court, maybe? Anyway, okay. With a couple more minutes we have, I'm trying to decide which of these. There's so many interesting provisions, and there's not been a lot of litigation about all of them. I think this is one actually that Blair, you might have mentioned the other day. A grandparenting time order does not confer custodial rights.
Yeah. Sub 9 and sub 10 essentially say these are, we're keeping you in your place, grandma and grandpa. Mom or dad, has the right to move. You're not going to keep them here because they got grandparenting time, and explicitly you're not elevated to that standing as a parent in sub 10. Yeah.
Lisa, and
yes,
that's what happened in our case. Remember, he
right.
took the child and moved out of state. Yeah.
He took the child to his parents and then moved out of state.
And then, no, but then eventually he and the child.
Oh, that's what happened later.
Yeah.
Oh.
It was continued.
Oh, I think you might have told me that a long time ago, but it's been a while. So there's a lot of other interesting provisions in the grandparenting time statute. We don't have time to talk about them all today.
I do want, can we just throw out 11?
Yeah.
Because I thought 11, I had no idea, right? I have yet to ever have anybody come to me saying, I want to terminate.
Not be modified unless there's a preponderance.
I want to terminate the grandparenting time. I've yet to see anybody come in and say, I want to stop the grandparenting time that's already been ordered. This provision says that now, essentially, the parent has to show that it's got to be terminated or modified because having it in place creates a substantial risk.
Mm-hmm.
So now you flipped it around.
Flip the burden. Yeah, that's a real, I haven't had one of those cases either, but it's a little interesting provision. How does grandparenting time impact child support? I'm thinking it doesn't. Blair, Judge Schlegel?
No, I don't think so.
Either.
No.
Any other closing comments from our guests?
Thank you so much for having me.
It's been a pleasure. Really enjoyed
Yes, it's been a real honor. I despite the time, I think, Lisa, you and I talked about, it's been quite some time since we had this case, but it's I'll always remember it. So, and I was so glad and so thankful you were on my team.
One extra wrinkle in that case, and it was a very emotional case, but I think one of the reasons that you and I both remember it so sharply is that at the time this little girl had her mother die and then she was taken away from her grandparents, she was in kindergarten, and we both had daughters in kindergarten. Oh. And the thought of our child going through that, I think, was just so profound. And a lot of cases I work on are very, significant and memorable, but that one was just really a special case. So thank you for involving me. Everybody in the chat, I thought you guys were wonderful today. Thank you so much for asking great questions. It really was wonderful to have you here. So thank you, Blair and Judge Schlegel. You guys have a great rest of the week.
Thank you. Pleasure to work with you, Judge.
You too, Blair.